So Jenny is the owner of Sacramento Legal Documents in Gold River, California. She's been providing legal document assistance since 1993 and has been a legal assistant for attorneys in labor law, workers' compensation, and personal injury. Jenny's been a member of CALDA for a very long time and served as secretary and is the new secretary, right, Jenny?
Yes,
Yeah,
correct.
awesome. Congratulations. We're happy to have you on board
Thank you.
again.
Everybody.
Okay. Jenny was born in Detroit, Michigan, and made her way to the West Coast in 1981. And she has been married to Frank for 20 years, has 4 adult children and 5 perfect grandchildren. She has mostly resided in the Sacramento area, but has also lived in Fresno for about 10 years. In her spare time, she enjoys reading, camping, and hanging out with family and fur babies. Awesome. And that's Jenny. And today, Jenny's going to talk about the basic default summary dissolution family law case. And then if you want the materials, go in your app and it's under the agenda for this class. There's some PDFs there, so you can follow along if you want to. And with that, Jenny, are you ready for me to share your presentation?
Yes, I'm ready anytime. Go ahead.
And then how long is your video?
It should be about an hour and 10 minutes. I left about 20 minutes for questions.
Okay, and then just a reminder, everyone can use the Q&A feature at the bottom of your screen to type out a question. I believe you can also do it anonymously, and then that's where we'll go to when we're going to start answering the questions during the Q&A. So thank you for being on here, everyone, and with that, I'm going to share my screen.
Thank you, everyone. Hello, everyone. I'm Jenny Beret with Sacramento Legal Documents. And today I wanted to talk a little bit about some basic divorce procedures. We're going to go over a default divorce without children and also a summary dissolution. I'd like to start today with the summary dissolution. And I'm going to grab the summary dissolution packets, get that on the screen here for us to review. Perfect, so hopefully you can all see that there. First thing you need to do is make sure that your clients qualify for the summary dissolution. It is a streamlined procedure. There's fewer forms that have to be filed, and of course it's less costly. There's only one filing fee, and you do not have to serve the other spouse. But it can only be used in limited circumstances, and this is how you would want to go over and make sure they qualify for that. So they had to have been married for less than 5 years from the date of marriage to date of separation. Now, if they have been separated and they just took a while before coming back to file this, that's okay, as long as their date of marriage, the date of separation is less than 5 years. They cannot have any children together, adopted or natural. They cannot own any real property. And they cannot rent any land or buildings except for their residence. They can obviously be renting a residence. But even on that residence, they can't have, they don't have a 1-year lease or option to buy, as long as they don't have a lease or option to buy. They cannot have more than $6,000 in debts that they've acquired as community property since the date of marriage. You do not count car loans in that. So that's outside of car loans, do they have more than $6,000 in debts? If they do, they cannot qualify for this procedure. They have to have less than $45,000 worth of assets that are community property. Again, you do not count cars. So that is purely any retirements, their 401ks they've gotten together cannot be real property, because that automatically disqualifies them and they have to use the longer dissolution process. They cannot have separate property worth more than $45,000. And that can be tricky if it is marriage later in life and people already, a 401k or a pension alone may have more than that. So at that point, they would not qualify for doing the summary dissolution. Again, in all 3 of these calculations, you do not count your cars, do not count vehicles. You have to agree that neither of the spouses will get spousal support, And you have to have signed an agreement that divides your property, including your cars and debts. And we'll talk about that a little bit more. And I am going to scroll down past the forms for just a minute and go down to where the booklet is. And you are going to have to share this booklet with your clients. All right, Summary Dissolution Information Booklet. It's FL-810 is the form number. Judicial Council, you get that at any of the counties. And you do need to send this, of course I do it by PDF, and send these to your clients. It goes over quite a bit of information, but the worksheets are the little bit that I want to cover here. Again, it talks about whether they even qualify for the summary dissolution. It talks about that again here, just what we went over. Lets them know if it's a domestic partner, there's actually a process through the California Secretary of State that has no filing fee. I have a little disclaimer here having to do with lawful permanent residents. Of course, if you are a lawful permanent resident, especially due to marriage or anything like that, you're going to want to talk to an attorney before filing for divorce. You don't want to make sure that your status is preserved and that you're not, it does not, as it says here, does not lead to any type of deportation. So please be sure that that is relayed to your clients. So this here just talks about terms, which we all know: community, separate property. Again, gives them a little bit of a checklist, whether they can file for the summary dissolution. Talks a little bit here about disclosures. And what I did want to show, though, is these sample worksheets. They are really great for helping them out, or even having the clients use these for the disclosures. So the first page is a sample. This is a sample worksheet for determining the value of separate property. And then the next worksheet is actually for them, and it is in a fillable format if you send it to them through PDF, and they can type this information in here: separate property. Another worksheet for the division of community property. This here, the first one again is a sample. It reminds them they cannot have more than $45,000. And then this is the form that they would fill out. As you can see, I filled it in with my petitioner's information. And then the last one is regarding community obligations, debts, basically. And again, shows a little bit of a sample of how to list those. And then you can come down here and do this for your actual clients. And then it talks about the property settlement agreement. Again, we're not going to go into that in too much detail today, but you can provide a settlement agreement if you choose as well. All right, so let's go back up here to the petition itself. All right, so one of the parties is going to have to be the primary and have their information listed here: name, address, phone number, all that good stuff. Of course, the captioning of the court, the county that you're filing in, is going to go here. And then you can see this is a little bit different than our standard petition. There's a petitioner 1 and a petitioner 2. There's not a respondent in this case. So they're both filing the petition together. They're filing for a summary dissolution of marriage. Again, that they can use this process for domestic partnership. For the sake of the sample, I went ahead and put a case number in here so you can kind of see what it looks like. However, obviously, if you're first filing this, you're not going to have a case number to put in there. The clerks will stamp that in for you. So the very first thing here is they are stating that they have read and understood the summary dissolution information booklet, that FL-810. That's why you do have to go ahead and give those over to your clients right when they're thinking about that. Make sure that they qualify. Date of marriage is going to go here. Date of separation is going to go right here. Less than 5 years between the date of marriage and date of separation. 5A and B are regarding jurisdiction. Usually you're gonna check mark 5A, that's the most common. If one of you has lived in California for at least 6 months and in the county of filing for at least 3 months, or you're only asking to end a domestic partnership, you would check mark 5A. The only time you check mark 5B is if you're actually married in California, but then moved to a place that does not allow same-sex marriage and will not allow them to divorce. So in that case, they can come back and do their dissolution in the county that they were originally married. It's not very common. It hopefully won't be common as we continue to progress. There's no minor children of the relationship. Neither of the parties has an interest in any real property. We're very specific about these. These again talk about those same values we talked about at the beginning. They have no obligation, no more obligations than $6,000. That does not include cars. They do not own more than $45,000 in assets. It does not include cars. That's community property. But then that neither of them has over $45,000 in separate property either. Does not include cars. Cars are not included in those totals. 11 and 12 is going to break into the disclosures, which are part of every dissolution, even the summary dissolution. We have filled out and given the other an income and expense declaration, FL 150. Now, of course, if it's very simple, they can also do the FL-155 and exchange that. That is just as acceptable. And you've got to let the court know how you've complied with the preliminary disclosure requirements. In this case, I wanted to do something a little different. So we just used the worksheets on pages 7, 9, and 11 of the booklet, FL810. That way I had those filled out and they exchange those. Or they can do the normal FL140, 142, or 160, and all the attachments to those forms. So either A or B, or excuse me, 1 or 2, it's perfectly acceptable. And then they're also the part of the disclosures, exchange of tax returns, and have made sure that they've told each other about any investments or income producing opportunities that have come up since they separated. 13A or B, you're going to check whatever is appropriate. In this case, I just wanted to do very simple, no community assets or liabilities. However, if there are some community assets or liabilities, you're going to check mark number 13B, and you're going to be attaching the agreement to the next form, the judgment of dissolution and notice of entry of judgment. Irreconcilable differences have caused a breakdown of the marriage. And 15A or B is asking if the petitioner desires to have their former name restored. In this case, I did have that for petitioner 1, but it can always be petitioner 2 as well. And then there's some basic things here that you just need to make sure that the client is aware of. They're giving up their rights to appeal or move for a new trial. Each of them is forever giving up any right to spousal or partner support. And during the 6 months after this is filed, they need to make sure that if either of them has a change of address, that they have to file an appropriate MC040 with the court, letting them know of their change of address. And here's the statement. We are submitting original and 3 copies of the proposed judgment. So normally we do 1 with 2 copies, original and 2 copies. In this case, we're going to do 3 copies. One envelope is addressed to the petitioner, the other envelope addressed to petitioner 2. So they also want you to include 2 stamped envelopes with the petition, pre-stamped envelopes. You need to make sure that they include enough postage for any attachments, any agreements or forms that are attached to the judgment as well. So not necessarily just a 55-cent stamp. You need to make sure that it's going to cover the postage for the entire judgment. And we agree that this matter can be determined by a commissioner sitting as a temporary judge. So mailing address for petitioner 1 here, mailing address petitioner 2, number of pages attached. In this case, I went ahead and attached their disclosures that they were exchanging. They're going to both go ahead and sign here. And here's those worksheets that I attached for their benefit. Again, this is a great thing to give to them, to have them fill out and help have them do the fillable forms. You can certainly help them with getting any kinds of agreement for the amounts or anything like that if necessary. This is for their debts. All right, then we're on to the judgment of dissolution and notice of entry of judgment. Again, the party, same party as we had in the petition, captioning here for the courthouse. And petitioner 1, petitioner 2, judgment of dissolution and notice of entry of judgment. I need to make sure I went over. I did miss that. I'm going to go back real quickly here, you guys. I want to make sure that you do see this and that this is pointed out to your clients as well. This little blurb right here. So the marriage will end 6 months from the date of filing the joint petition. Both petitioners will receive a stamped copy from the court with the judgment of dissolution and notice of entry of judgment. That's the next form we'll be going over. Until the effective date specified on FL 825 for the dissolution of your marriage, either one of you can stop this joint petition by filing a notice of revocation of petition for summary dissolution. This is going to be form FL-830. If you stop the joint petition, you will still be married or in a domestic partnership. So I just wanted to make sure and point that out because I did not have that form in our packet. I've never had anybody stop it before, but that could come up. If so, anytime once they file this, it's basically going to sit with the court for 6 months until they're ready to enter into the judgment. And during that time, if one of them decides, no, I think this person's hiding things from me, or just found out I was pregnant, or anything, decided they wanted to try and get spousal support for any reason, they are going to have to go and file this FL 830 and file that with the court. So just wanted to make sure and make that really clear, both make that clear to your clients that they can stop this once it starts and enter into a full-blown divorce at that point, because that's obviously going to preserve more of their rights than the summary dissolution. Summary dissolution is, again, a shortened procedure, and they can't enforce as many rights as they can when they're doing a full-on lawsuit dissolution. So just be aware of that. All right, so there's also a little disclaimer at the bottom talking about the partner's will, retirement account. Dissolution automatically cancels the right of the other spouse to receive anything under those type of survivorship benefits. That's a little blurb on the bottom of the joint petition for summary dissolution. All right, so back to the judgment. Judgment of dissolution and notice of entry of judgments. So if you know the date that you're filing the paperwork, you can actually go ahead and put that date in here. If you're just dropping off or you're dropping it with your court runner and you're not really sure the date it's going to get filed, I would leave that blank and the court will go ahead and stamp that in for you. I've never had a problem with them doing that with any of the counties that I've worked in. The former, you're going to want to restate here again if one of the petitioners wants to have their name restored, and put their name here. And the judge will sign here, date here. Actually, look at here is that little notice that I was just talking about. That's also on the petition, but again, it's on here. So dissolution may automatically cancel the rights of a spouse or domestic partner under the other spouse or domestic partner's will, trust, retirement benefit plan, power of attorney, pay on death bank account, transfer on death vehicle registration, survivorship rights, own a joint tenancy, blah, blah, blah. It does not automatically cancel the rights of a spouse or as a beneficiary under a life insurance policy. So you need to make sure and review those matters. So if you have Again, that's just part of the housekeeping when you're going through a divorce. You want to make sure you're taking the X off as on your insurance plans and anything, especially the insurance plans, because your dissolution does not automatically cancel them off of the life insurance. So if they no longer want their spouse to be named, they need to make sure and take care of that ASAP. So then we move on to, you're going to want to have this box check mark for the court. Either they're getting the judgment of dissolution or domestic partnership. Most often it's going to be marriage. And the clerk will do their little deal here. They'll stamp it, they'll sign it. And here in the clerk's certificate of mailing, they will go ahead and date it here, date, sign. And of course, this is where you want to have the envelopes attached with sufficient postage so they can attach this judgment along with any settlement agreement that might be attached. Or I attached those forms to the petition just for the sake of looking at those, but they could also be attached as a division of property, but it does need to be signed by the parties. So you have to put it into an agreement format showing who is getting what and have the parties sign those. So it's a fairly easy process. Again, basically what, 2 forms along with the summary dissolution information packet. Although you do have to, if they have any kind of assets or debts, you do need to do that settlement agreement. So that's also a little extra that you'll be doing. You'll have to help them with disclosures, but they can also, you can also opt for the more streamlined and have them exchanging the worksheets. But they do have to fill out the income and expense regardless of whether they do the 142, use those forms, or they use the worksheets. Still have to do an FL 150 or an FL 155 for sure. But once you get that all clerked in, then like I said, the court sits on it. 6 months later, the parties will get their documents to them in the mail, or and you can also have an envelope in there for you as well. So you'll have an envelope, they'll send it directly to the clients, and then you can have a copy come back to you for your file as well if you like. And that's pretty much it for a summary dissolution. Go ahead and leave some. Let me stop sharing this. All right, so now we're ready to dive into a basic default divorce. And again, I did this without children. In the next session, in the advanced dissolution with children, of course, we'll be going over that a lot more detail. Let me get the material pulled up here. Give me 1 moment. Okay, here we go. Oh, this is halfway through. All right, so for basic default dissolution, but this is a full default. In this case, we started out hoping that this gentleman would participate, but he did not. So let me go through and we'll kind of go through all of the forms for that. So you're going to start with an FL 110. That's your summons. Notice to respondent, petitioner's name of the courthouse here, information on the courthouse, and your petitioner's information here. Standard restraining orders are included. You can go ahead and read it down here. The parties are not supposed to remove any property or cash out or borrow against any type of community property. They cannot cancel each other off of the insurance until the dissolution is complete. So some basic restraining orders that people will be aware of. Next form is the FL 100. Again, you're going to be putting the captioning for your petitioner up here, court information here, and we're filing a petition for dissolution or divorce of marriage. Number 1, you're going to check mark one of these boxes. We are married. It's the most common. Number 2, again, is for residence requirements, jurisdiction, and at least one of these has to have been a resident in the state for the last 6 months and in the county for the last 3 months. If it's both of them, it's okay to check mark both. If it's only one, check mark one. And you do B and C if they apply, but they're not common, not as common. Statistical facts. So date of marriage, you're going to check mark and put the date of marriage, date of separation, and then down here putting the time of the date of separation. In this case, as you can see, it was a very short-term marriage. There are no minor children, so none of this applies. We are asking for divorce on the grounds of irreconcilable differences. Number 6 does not apply, there's no children. Number 7 does not apply, no children. The petitioner is asking to terminate the ability to award spousal support to either the petitioner or the respondent. And you can choose whichever best suits the needs of your client. Separate property. I always put this little blurb in, even if they have no separate property that they want to make sure is confirmed. Any and all assets acquired prior to the date of marriage and after the date of separation, and any inheritance or gift as defined by California law. I have them confirm that, both the petitioner and the respondent. Now, if there is something, say maybe a classic car that they came into the marriage with, or some type of inheritance, and they just want to be sure that it's made clear that that is their separate property, and especially if you think that it's going to be by default, you're going to want to go ahead and list that in here. You can still do this little blurb, and you do not have to do the one for the respondent. I just tend to do that if there's nothing else listed here. But if you had to use up the rest of this to put, you know, classic car, pension, you know, anything that they feel is their sole and separate property, not community property. It couldn't be a pension if it was still being added to, that would be more in the community property range. But especially if you think it's going to go by default, you want to go ahead and list those items here, or include, you can always do the property declaration, the form FL 160. You want to try and mirror anything in your petition that you're going to ask for in your judgment when you're doing a default. It's your quickest, easiest way to get the judgment, and most likely will not trigger a default hearing. So depending on your county, most counties don't do default hearings anymore unless the judge feels that it's necessary, or the client specifically requests a default hearing. It's just, you know, courts are busy, and if there's no need for it, there's no need for it. My clients always like to stay out of court, so I try to get everything through on paperwork as best as possible for them. And that's why I'm bringing this up regarding their separate property. If they specifically want something claimed to them and you think it's going to go into a default, list it here or attach a property declaration form FL 160, so that by the time you get to the judgment, both of the forms are matching, and the judge knows that you have served this on the respondent, and the respondent is fully aware that she or he is claiming that as their own separate property. All right, community and quasi-community property. I do have another sample in just a bit that I'll show you regarding that has property attached. For the purposes of this first one, we're going to say that there's no assets or debts that need to be divided by the court. So super straight and simple. Really doesn't even require any kind of extra documents or anything when we get to the default. Other request, the petitioner was requesting her former name be restored, so that's in there. And then you're going to have them sign here. Some people also put their name here, comma, in pro per, and have them sign for themselves as petitioner. Unless your court specifically found that they like it both ways, you can kind of do it. You can do it either way. But there are some courts who like the petitioners to sign as their own attorney. All right, so next we're on to any kind of local forms. This is actually a Sacramento local form, so I wanted to throw that in there to talk about that. Make sure that you're checking your county and providing any local forms that are necessary. This one here in Sacramento, authorization for non-attorney court document preparer. I forgot that once in someone's divorce, and they did not send the documents back to me. They sent the documents directly to the clients, which means that unless they put a label over my postage, my postage and my envelope went unused, which is frustrating. So just make sure you're aware of that. And sometimes there's depending on the county, especially larger counties, could have a couple different local forms depending on what type of if it's default agreement, if there's children involved. So make sure you're checking that very well and looking at their samples. All right, so in this case, we went ahead and did her disclosures right away. There wasn't a lot to disclose, and we weren't sure whether he was going to participate in this divorce or not. So we wanted to make sure he received the documents when we served him. So you're going to be doing this step either right at the beginning, or of course, once you get them served, you can always do the disclosures after that. If your party is difficult to serve or they're not sure their location, I would recommend that you get the disclosures done first and have them served at the same time as the summons and petition, so that you're not having to try and find them again to serve them properly. So, declaration of disclosure, this is the preliminary and final. We're including a FL 142 and a 150. That's what was served on him. I'm going to sign here. This is the form that's going to get filed with the court. FL 141, declaration regarding the service of declaration of disclosure, income and expense declaration. Let me regress just a little bit. Digress. This, even though this looks like that they will file it, so there's a filing box. Do not file this form with the court. This does not get filed with the court. And it even says here, do not file declarations or disclosures or financial attachments with the court. They do not want that in there. But this one does get filed with the court, the FL 141, and this is your proof of service, basically, that they were served with the disclosures. Now, in this case, I only put the preliminary. You could actually check mark. I missed that check mark. That actually should be, that box, that final box should be check marked. So petitioner's preliminary and final. Number one, I am the petitioner in this matter. The petitioner's preliminary declaration of disclosure and income and expense were served on the other party by personal service on this date. This is if they did final declarations of disclosure, but again, like we said, we're going to go ahead and waive the second disclosures, the final set of disclosures. So service of petitioner's final declaration of disclosure and current income and expense declaration have been waived as follows. And in this case, because it is a default proceeding, we're check marking 4C. This is a default proceeding that does not include a stipulated judgment or settlement agreement, and the petitioner waives final disclosure requirements under Family Code Section 2110. So they're going to sign this, and this is going to get filed with the court. And again, they have a little note down here, just in case it gets confusing. Note, file this document with the court. Do not attach the preliminary final declaration. That was the 140 with any attachments. All right, FL 142. You can always use an FL 160 as well. However, the 142 does not get filed with the court, and so whenever possible, I try to keep my client's personal business out of the court file. Now, if there was a lot of property, and actually we'll talk about that when we get down to the next set, when I talk about some properties. I'll give you some suggestions there. But in this case, there was no assets or debts for the court to decide, so I went ahead and did this on a 142 to keep the petitioner's information and the respondents technically out of the court file. So here we just filled these in with the information provided to me by the petitioner. They each owned a mobile home. I went through and put the respondent's items as well, so that when he did receive those, he saw that she was claiming that as separate property for each party, so that there were no arguments or anything he was afraid that she was going to go after. We've got their vehicles listed here. So this one to stay with the petitioner, this one to go to the respondent, approximate values, their savings accounts. It is okay to put the last 4 digits or account ending. We just did not have those. We did not have his information at the time, so we just let it go at this. Life insurance policy she had. Of course, just fill it in based on what your client and the information the client's giving you. Petitioner, respondent, all the way through. And here we go with the bills. All right, and then we're on to their financial statement. Must file an FL 155 or an FL 150, and this does get filed with the court. In this case, I did the 155, as simple as possible. I had the client fill it in appropriately. There's no children. They're not receiving this only source of income here, and there's no children. My client was receiving some wages and also retirement. None of this applied. If it does, put it, write the amounts on the side. Monthly housing costs. They, in this case, there's a mobile home that was rented. That she owns a mobile home, but she rents a space for it. So that's why we put mortgage plus space rental here. Employer information. And the estimate of the other party's gross monthly income. Most of the time I try to get them to get close to that. She just had absolutely no idea, so we put unknown because we're not asking for any kind of spousal fees or anything of that nature. It's not going to be really reviewed too much by the court. Attach pay stubs and send those as well. Federal tax return. Those need to go to the other party. Now, unless I'm dealing with support issues, I do not attach their copies and file to the court's copy that I'm filing. There may be some counties that require it. Sacramento does not, and so I will just file the form, the FL 155. I will attach the pay stubs to the proof of service when I send them, so that we're satisfying the disclosures. However, again, I try to keep as much information out of the court file unless that has to be done. In some cases, when we're talking about spousal and child support, you don't really have a choice but to go ahead and file your pay stubs. And pay stubs in general are pretty much redacted. You're going to want to look over and make sure that you're redacting any personal information. Most of them are pretty redacted as it is. However, if you file income tax forms, you're going to want to make sure you're redacting part of Social Security numbers, only leaving the last 4 digits, or redact them altogether. You don't want that information in the court file. Just be cognizant of those things. All right, now the proof of services summons. Originally, we were sending this to him to sign. We ended up actually having to have him serve because he would not participate. But when we filled out the proof of service, check mark the first box you're going to check mark pretty much in every case when you're doing a divorce. So that has the FL 100, the summons FL 110, and the blank response form FL 120. So be sure you're sending a blank response form. But also we went ahead, like I spoke about earlier, we added her disclosures into this as well. So check mark D, FL 140, FL 142, and FL 155 are included in the service. Address where he's being served. And again, originally we tried to, and that's why I included this for the sample, we went to send him a notice and acknowledgement of receipt whereby he could just sign for his documents himself. We need to fill out the person who served the papers if it's you or anybody else. I am not a registered California process server. And I declare under penalty of perjury, you only fill this one out if you're a sworn officer. I'd sign here. Here is my notice and acknowledgement of receipt. I am naming to Jeffrey here. Date of mailing, this would have matched the date of mailing on the proof of service. But again, like I said, didn't work out in this case. And you want to mirror this as well. The documents that are he's acknowledging receipt on, this should look exactly like your service of summons, proof of service of summons. As you can see, these all match up here. All right, so now you've served your documents, whether they signed for them and you filed the notice of acknowledgement, or you had to find the respondent and have them personally served, and you've waited 30 days after they're served. You must wait 30 days to see if they file a response. If you try to file your request to enter default too early, the court will kick it back and you'll have to get a new signature and do the whole thing all over again. All right, so 30 days has passed in this case. And we're gonna go ahead and get our default filed. So at this point, you should have the case number on all the rest of your documents. In most cases, I'm not reattaching the FL 150, 155, or the 160. And if you do not attach it, it's not attached, it's not attached. You need to make sure you can at least check at least one of these boxes. So there's been no changes since the previous filing. There's no issues with child, spousal, or partner support. The petition does not request money, property costs, or attorney's fees. And there's no issues of division of community property. So you can check mark as many of these boxes apply, or at least one of those. In the next session, we'll be talking about a settlement agreement. And so actually this box will be checked and pretty much no others. So if it has been a while or these need to be updated, that's just exactly what you're gonna do. You're gonna update these forms and attach them onto here. So number 3, and then of course your client signs here. Number 3 is the declaration to enter default. So in most cases, you're going to be checkmarking 3B and providing the clerk with an envelope of the respondent's name and address on them. The respondent's address goes here. If you are including copies of updated FL 160s or 150s, please be sure that you're putting enough postage on your return envelope. It's obviously going to be larger than a standard number 10 envelope with 55 cents postage. So make sure that you're weighing that out, that you've got sufficient postage on your request to enter default. You're going to be attaching that to this form when you turn it into the clerk's. Now, in the case where you received order for publication or posting to the respondent because they could not be found, you would then check mark 3A, and of course you would have no envelope attached because there's nowhere for it to go to. In order to receive an order by publication or posting, that is a separate step, a procedure of due diligence that you have to send to the judge and request an order allowing you to serve it either by publication or posting. And then of course the client's going to sign here. Coming down to memorandum of costs. Costs and disbursements are waived. That's normally going to be what you check, but if for some reason I've had people who want to be reimbursed for the respondent's half of the fees, you're going to go ahead and check mark these boxes and put the prices in accordingly. And declaration, of course, they're going to sign here. Declaration of non-military status. The respondent is not in the military. So you're going to sign here. If the respondent is in the military, there's additional forms and additional steps that need to be taken for that as well. Once the request to enter default has been entered, you're actually going to see there's little, the clerk is going to check mark this box, or they'll check mark these two boxes if it's entered. If it's not, they'll check box 3 and tell you why. So if you had just an error on your form, or the respondent filed a response, or you know, whatever the reason was, they'll put it there so you can correct it and resubmit it if you need to. Otherwise, you'll get some check marks here with the dates and the clerk's signature, and you know that the notice for default got sent to the respondent. All right. Headed down to the declaration for default or uncontested dissolution or legal separation. This is the form FL-170, and this is the form that basically keeps them out of court. In most cases, the judge is going to use this as their declaration, and so, you know, instead of going to court, you're being sworn in and giving oral testimony. You're filling out this form to let the judge know what issues need to be taken care of and decided for the judgment. And you can see that by this number 1, this very first line here. I declare that if I appeared in court and were sworn, I would testify to the truth of the facts in this declaration. So again, it's just a substitute for having to go to court, which is great. And I agree that my case will be proven by this declaration, and I will not appear before the court unless I'm ordered to do so. All the information in this petition is true and correct. If it's amended, make sure you check mark that box. That does come up from time to time. Most of the time I don't check mark response, very rarely use that, but you have that option. In this case, we're gonna show default without agreement. This is just a pure straight default. No response from the respondent whatsoever in any form. So we're gonna check mark A, box 4A, default without agreement. And then there's no written agreement or stipulation between the parties. The default of the respondent is entered or being requested, and you're not seeking any relief not requested in the petition. Again, that's where it goes back where I put all that extra emphasis on the original petition. If you don't think the other party is going to respond, or that this could end up being a default divorce, you want to make sure that you've got all the separate property and all the community property listed in that original petition. You can attach forms FL-160. You can attach one for separate property and one for community property. You can list them out, but you definitely want to make sure that that is in the original petition so that everything mirrors and matches up, and the judge knows that you've given proper notice to the respondent that you are dividing those assets, or what you're considering separate and community assets. In this case, we're going to go for the simple thing. There's no assets or debts to be disposed of by the court. 4B is default with agreement. We're going to talk about that more tomorrow. And C is uncontested. I'm going to talk about that a little bit more later, not tomorrow. I'll apologize for that in the next session. And uncontested is just when the respondent has filed a response. So now it turns it into an uncontested if they move forward together on an agreement. Declaration of disclosure. You're going to choose either 5A, B, C, or D. In this case, this matter is proceeding by default, so we are check marking 5B. Now, there are times, so let me finish reading this. I'm the petitioner of the action and filed a proof of service of the preliminary declaration of disclosure. I hereby waive receipt of the final declaration of disclosure form, FL-140. There are times when you could do a default and you're going to, you'd be check marking box A because both parties went ahead and filed those things. That's, again, that'll be a sample in the next class, the more advanced dissolution proceeding. Or 5C is if it's default and the notice was posted or published, then you're going to be checking that. And then 5D is if this matter proceeding as an uncontested action, where that's where both parties have appeared. The respondent has filed a response, and so, but then they work their things out and they're moving forward with an agreement or uncontested. They're not going to court over it. That's the box you check there. In this case, there is no child custody or visitation that's being discussed, so we do not check mark any of these boxes. No child support is going to be determined. So we're not check marking any of these boxes. This is this sample, but again, If you are doing a default with child custody and visitation, you want to give as much information as you can to the court in regards to the situation so that the court knows. Spell it out for the judge. No child support. So spousal support. Do you want to check at least one of these items here? In our case, we're asking the court to terminate spousal and partner support for forever for the petitioner and the respondent. Parentage, we leave blank. There's no children. Attorney's fees are blank. There was no attorneys involved. And again, the petitioner requests restoration of her former name, so we check mark that box as well. You can read these statements here. They apply to dissolution. If the marriage or domestic partnership was created in another state, anyway, this just talks about, again, jurisdiction. You're asking the court to grant the judgment of dissolution based on the orders set in the judgment, which is Form FL 180. If it was a status-only judgment, you would check mark this box. That goes when you do a bifurcation. And this applies only to legal separations. If there's any other orders, you can check mark this box and put other orders as specified in the judgment or something along that lines, or specifically put what that order is. And they're going to sign there. Then we move on to the judgment form. So again, this is going to be for a no assets, just purely quick and easy default. Customer's information there, court information there. This is for judgment for dissolution. The date the marital or domestic partnership status ends. So in this case, we went ahead and got the documents ready to go prior to the date, the 6-month period of the dissolution. So it goes 6 months from the date, 6 months and a day from the date that the respondent was served. So in this case, he must have been served on, yes, he was served on June 4th. So 12/5 is going to be 6 months and a day is going to be the date that their marriage ends and that they're restored back to single person status. This proceeding was heard, back up to number 1, if there's restraining orders, you're going to check mark these items here. This proceeding was heard as a default or uncontested and by declaration under Family Code Section 2336. So it was default, and then the declaration is that FL-170, and that's what that checkbox is for. None of this is going to apply. They did not appear in court. The court acquires jurisdiction of the respondent on June 4th when the respondent was served with process. And the court orders, good cause appearing, that the judgment of dissolution is entered, that the marital status is terminated and the parties are restored back to single person status on December 5th, 2020. So this judgment could have come back in, say, October, finally all done by the judge, but that date is in there to let people know, even though the judgment's been entered, you cannot get remarried, you're not restored to single person status until that 6-month statutory time period is up. And that's in every divorce, 6 months from the date of service, not from the date of filing, from the date of service on the respondent. These items don't apply. Petitioner's former name to be restored to Susan Reynolds. Doesn't apply here, no children involved. And then these are the issues that you're check marking to bring to the judge's attention that you need a decision made on. There were no children, so nothing listed here, no child custody, no child support. Spousal support, the jurisdiction is terminated to order spousal support to either the petitioner or respondent, so she terminated spousal. And then they didn't even have any property, so as you can see, it's super, super easy judgment to go through. I didn't even do any attachments or anything, nothing really to let the judge know more about. So that's the judgment, and what we're waiting for is for that to come back with the date and the signature and the stamp up here in the upper right-hand corner. And that's the date that we know judgment was entered and that and that they can get moving forward in their life, although they cannot remarry until that date there. If you submit the judgment and the 6 months statutory time period has already passed, you're going to want to leave this blank. The court clerk will stamp in the date that the judge signs it, and that's the date of dissolution. So again, if prior to the 6 months statutory time, you're going to go ahead and put the date in. After the 6 months statutory time, leave it blank, and the court will just put a stamp on it, the date that the judge signs it, and that's the date that their divorce is final. One last form that needs to be filled out is the FL 190, which is the notice of entry of judgment. The clerk is going to go ahead and stamp here when the judgment was entered. That's the date that the judge signed it for dissolution in this case. Of course, will be stamps here in the clerk's signature. Now here again, because this is being submitted prior to the 6 month statutory time period, you again put the date in here that they're not effective date of termination of the marital status is 12/5/2020. Neither party may remarry or enter into a new domestic partnership until the effective date of termination as shown in the box. You're going to go ahead and fill in the addresses of both parties. And again, for this notice of entry of judgment, you include a number 10 envelope with the names on there, self-stamped. So this will take the 55-cent stamp, 50.55. Not even sure what postage actually runs. I just put it in my postage machine. And then the court will send that directly to the clients so that they know a judgment has been entered against them. All right, so I also wanted to give an example of doing the default with property. Now here I just put currently in discovery because I pulled this off of one and I just wrote in something quickly. However, like I said before, you want everything to mirror. So I would normally, if I knew it was going to end at a default for sure, I would actually check mark in the declaration form FL 160 and include that, especially if there's you know, quite a bit of property. If there's only 1 or 2 items, you could easily just list them here. But if you're getting more than that, I would recommend you attach the FL 160 to it. So that's the only difference than everything else from previous. All the other first couple pages, this is only the last form here to show you as an example. Pages 1 and 2 are going to be the same as previously shown. But now what I did, I used to do this a lot in Fresno. They actually gave this as a sample, is they would have you do the declaration for default for dissolution, but they would have you attach, and I'm going to scroll down kind of quickly here, an attachment to the declaration for default. So we included as attachment 19. Please see attachment 19 incorporated herein. Otherwise, we do these things the same as I showed on the last one. This actually should be the community and quasi because this is with property. So you would actually check mark this box instead. Come down here, come down here. And you want to go ahead and just lay things out. Parties were married, the parties in this case were married in this date, separated on this date. Issues related to childcare. So party in this case have no minor children, so nothing's going to be laid out there. If there were, I would put this. I would put what they're, you know, currently the children are residing with the mother. They see the father every other weekend. From this time, I would put all of the information down there. You want the courts to know exactly what's been going on when it's a default. You know, the courts like to hear from both sides and be sure that that both sides are aware of the lawsuit. So whenever you're doing a default, it's already a red flag to the court. And if you've got issues with children or quite a bit of property, you want to really, really spell things out to the court and let them know that you're not, that you're letting know the current custody situation, whether the parent's participating in their life or they don't ever see the children, all those types of things. It's also going to be important because of the child support that the court will set. And in this case, I would also attach I mirror what's on here to what's on the judgment. So I would actually, if there were children involved and you were doing a straight default, you'd want to have to do calculations, do your cal support or Disomaster, attach child support calculations, as much information as you can give the court as possible. Will keep you from having to go in and do a default hearing. But again, this is the simple version. So no child custody, visitation, or support to talk about here. Spousal support, petitioner is requesting no courts, is requesting the court do the following as to spousal support. No spousal support shall be paid by either party. Court hereby terminates this jurisdiction. Property division. So this is where they had a few items to divide. Again, you could just put, please see attachment 160, and you could attach 160, or you can lay them out in the pleading like I've done here. It's just another example of a way to get it done. You know, we have the forms as well, the FL 160, or and if there's or you can lay it all out on here, letting them know. So the petitioner is requesting the court make the following orders regarding separate and community property and debt. So each party shall be awarded their personal property in his or her possession. Petitioner shall be awarded the following assets and debts. So assets and their value. The respondent shall be awarded the following assets and debts. And it's a vehicle. As you can see, there's actually more that's being awarded to the respondent. When you're doing a default, if you're actually giving the respondent more, you're not going to get that kickback by the court in most cases. However, if you are taking more, you're taking the full, you're taking the house or things like that, you're going to really have to lay out your story to so that the judge understands, and again, make sure that's mirrored from your original petition, that you made it clear that you are going to be asking for the house to be your sole and separate property. And there were no attorney fees in this case, so we check mark that box as well. So I attached that to the declaration. Just provides, again, additional information for the court, different, and you can, and of course you have more room, so you can say, you know, he left and he left these items here, or the party took these items, or, you know, there's just more room to really lay out your case if you needed to on the attachments. And so what we would also do is mirror that and attach it to the FL 180 and to the judgment. So this would all basically stay the same as the first example we went through. However, we would check mark the box as property division in this case, and please see attachment 4.0 incorporated herein. So here's where we put the attachment to the judgment. Court finds, petitioners write it, here's your basic dissolution information, just restating the date of marriage, date of separation. There was no child custody, visitation, or support in this case. Spousal support, again, asking the court hereby terminates this jurisdiction to award spousal support in the future. So this is mirroring the previous attachment, but now this is the order itself. So the language is slightly different. Property division, again, exactly as we had it on the declaration. So now that when the judge signs this is being awarded directly to these persons, to the persons. Attorney's fees, no attorney's fees shall be paid to either party. But this is where you could put attorney fees and filing fee, you know, and reimbursement of fees if the party wanted it, and things of that nature. And then the judge is going to sign here. So since the judge is going to be signing this this attachment, you would actually want to check mark this box, signature follows last attachment. So you may want to jot that on your notes if that's the case, if you were to do this type of attachment. If you were attaching just FL 160, or also note that these forms here, these can all be attached as well. I'm actually going to attach some of those in the next sample in the more full dissolution procedure. All of these forms can be used as well. Property order attachment to judgment, so FL 346, FL 345. Again, with the children's custody, all these different attachments. So I am going to show a sample of that in the next class as well. Those forms are great. They're there for your needs and cover pretty much everything you could possibly think of. And so, you know, I go more with the forms. I wanted to show that attachment sample as just another way. But if you were going to, these days, the forms are so, they just have so much information on them that I just think that that actually gives better information to the judges than these attachments that I used to use. So, but it's a quick and easy way, and the courts do appreciate you laying out the issues in as much detail as possible. So, then the judge will sign, and that comes back, and your parties are divorced. Oh, I'm gonna stop sharing the screen here. Love to hear if anybody's got questions regarding either the summary dissolution or the simplified default, no children default. We'll go into the children much more in the next class. But I'd be happy to take some questions and give some feedback and clarification as I can.
So what we're going to do is we're going to start the Q&A portion, and so I'll read out the questions, and then Jenny, you can answer them. I believe we have until 10:30, and it's 10:08 now, so it's perfect. And so we did 2 different processes, so I'm going to go into order that the questions were asked. Yeah, so that the first ones were probably about the summary dissolution. So good morning. Do the disclosures, regardless of which they decide to use, do they get filed with the court?
Yes, yes. And you know, when you think back after you record these videos, I even thought about that, and I should have mentioned that in the video. You are going to file the 155 or the 150 with the court, and I would actually also file the declaration of the declaration of disclosure, the FL 141, with the court as well. So I apologize for not putting that in the packet, but yes, you would file those disclosures with the court. Of course, if you're doing the FL 142, you don't have to, or if they're exchanging the worksheets, you're not going to file those with the court either. But I would do the financial and the 141, same as any divorce.
Awesome. Next question is, what if it's a same-sex marriage and wife 1 is pregnant?
Well, then you cannot use the summary dissolution. Any pregnancy, whether it's same-sex, again, whether they're adopted children, so if it was same-sex but they adopted a child, you cannot use the summary dissolution. They would have to kick it over to a full divorce.
Thank you. Catherine's question is, what are the steps for processing it with the court? Do we file the petition and all the documents, including judgment, at the same time, or file the petition first, get a case number, then do the remaining docs?
No, you actually file it all at the same time. They usually will stamp it in. I haven't done one up here in Sacramento yet. I did quite a few of these back in Fresno. And because I would take them in for filing, I would actually write the date in, the date that it was filed, in that little box for the determination date. But they will stamp it. I have had the court stamp that before, just do the math for you and stamp it at the right time. But you are supposed to send it all to the court. But again, every county is a little bit different. I would double check with them. Maybe they want you to wait until the 6 months. Maybe they don't have the staff that can go in and double check and make sure that you're, that the 6 months has been done. So you'd want to definitely double check with your court and be sure of that, because honestly, having the court try and follow up and make sure it's done in 6 months is probably it's probably not going to happen. So I'd really watch over that, or just check with them. They may want you just to submit it at the 6 month period.
Thank you. Next question. Do you have a sheet you hand the client that shows all the documents needed in this process? Since we're not allowed to select the document for the client, if you have one, do you have one you can share with us?
Well, for the summary dissolution, and yes, I can share it. I've got your emails that are going here, but for the summary dissolution, you just use that FL 810. That pretty much lays out, you've only got really those 2 forms, or the revocation form if necessary. It lists the judgment forms on there, or excuse me, the disclosure forms on there as well. So for the summary dissolution, it's right in that FL 8110, that packet. For a regular default, I do actually have a sheet that I showed from Sac County that lists all the forms, and I'd be happy to show that to you guys. Most counties give you a list. Some of the smaller counties, or if the website's not as robust, obviously they may not, but I'd be happy to share a list of the forms. And yes, I do the same as all of us, just say, these are the forms, Sacramento says that we need to file, or El Dorado, whatever your county is, would you want me to you know, do these for you? And they say yes, so I'll share that with you.
Thanks. Angela's question, judgment form FL825, item 1A. Does the clerk not enter the date of dissolution in this space?
If the clerk is, if they are having you submit all the paperwork at one time, the clerk's going to put that date in there because you have to know the date of filing. Everything's a little weird right now with COVID. You know, used to be able to just go, in Sacramento, we still can't go into our courthouse here. I know some you can. So if you're turning it all into the clerk at that time, they're going to put those dates in there for you if that's their procedure. But if they're wanting you to file the judgment form at, you know, when it comes time for 6 months, then you're going to put that date of dissolution in there. You're going to have that completely filled out for the clerk when you send it in.
Okay. Marina's question, does the local form for doc preparer need to be filed with each set of forms you file, or just one time?
Just one per case. Once it's in the file, they're good with that. So yeah, just one per case.
Okay. And they're asking, what is the game code for this class?
I don't know. Do you? I'll have to get that because I don't know. I was not given that. So I'll find out. I'll make sure that that's posted for everyone.
Okay, let me see. I think I do know the 9 o'clock basic summary. I believe it's easy goodbye. Okay.
Easy goodbye. I like that.
Yeah, I think it's called easy goodbye, but don't quote me on that. Try it. I'm just put it on the Q&A answers, I believe. What do you charge for summary dissolution, or what would be a good range that people could charge?
Yeah, I would say depending on your county, I would go anywhere from $400 to $600. You know, some more seasoned people can charge a little bit more because they're charging more for their full divorces. But I wouldn't go under 400, and I figure at least a couple $100 per form you're filling out and disclosures that you're doing and everything. But 400 to 600 is probably good. Maybe even up to, I don't know, 800 seems a little bit high to me, but that's my personal, based on my customers coming to my door. So yeah.
Okay. Laura says, where are you putting your LDA stamp?
I know I pulled these all off of just straight out of my computer, but I actually have a stamp because I use LaYa and they don't have the stamp. That is one of the benefits of essential forms, I will say. So I do stamp them with, I do have a little stamp, and I basically put it in the upper, right next to the client's name, unless there's just no room there. And I'm gonna, then I find maybe towards the end of the document or somewhere where I can put my stamp nicely. If it's a pleading, I put it in the little edge of area on the right-hand side of the page, and it's kind of faces differently. But yes, I normally would have those all before submitting them. You want to make sure your stamp is on there.
Perfect, thank you. So let me see. So I think now we're moving on to the regular divorce questions,
Okay.
I believe. So Myrna asked, if you mentioned spousal support in the petition, I guess you have to file the FL-150 and not the FL-155, correct?
That's absolutely correct. If you're asking for support for spousal or child support, I would do an FL-150. If they're not asking for support, or there's no children involved, or, you know, in my next session, we have an agreement that the parties enter into, then you can do the simplified form. But if they are asking for any type of support, or attorney's fees, even for, you know, maybe they had an attorney to begin with and come into you later down the line, you want to do an FL-150, the longer
Thank
form.
you. Okay, Marina's question, the attachment number 19, is that essentially an abbreviated MSA?
Well, yes, except for it's not being signed by both parties. So it's really, again, like I said, that's kind of the old school way. I think the forms now are much better. They're done really well. They include everything. But I wanted to give that because it's just another way that they'll take that information. So yeah, you're laying everything out, but you're not getting both persons' signatures, but you are at least letting the judge know, especially when it comes to children and stuff, you know, whether they're the other party's been involved in their life, and why you're asking for those particular custody orders.
Thank you. Now this is about financial disclosures. Lori's question is the requirement for proof of service of disclosure taken care of in the FL 170?
No, for proof of service of disclosures, you're going to file the FL 1-141, or well, you're going to file that regardless, even if you have it listed on your original proof of service for your summons. How I did that in the one time where we gave them all the financials right then and there when we served them. That's great, but you still want to file the FL 141.
Okay, we have a question. Thank you. We have a question. How do you request documents from the customer to complete the financial declarations? Is there a worksheet or questionnaire somewhere? Does someone have one to share here?
Yes, and there's actually, I do have a sample in the next class of the CALDA dissolution intake form. And there is actually one for a summary dissolution, and I apologize, I forgot to attach that to the packet. But if you do go on the CALDA website under our forms, there is one for a summary dissolution as well. And of course, the FL, if you're doing the summary dissolution, the FL 810, that has those worksheets included right in the packet that people can use and send to you. They're fillable and everything. Otherwise, you can use the CALDA forms. I personally, I give the FL 142 directly to my clients and make them fill that out, and or the 150 and 155. I have them fill out the actual forms, and I tell them they can mark it all up any way they choose, that I'll be retyping it. But that's what I use. I think it makes it easier for them to see it exactly how it's going to be laid out on the form. But you can also use the intake forms from CALDA or make your own.
Okay, perfect. Question. I have a default dissolution that I took in the final stage. The customer prepared her initial docs. The question is, I keep getting it rejected based on the fact that she did not mark either box for spousal support for either her or the respondent. How to complete the FL 170 regarding spousal support?
So
That's by Victoria Edwards.
I see that. So, well, I mean, if they will allow you how to complete the FL 170 regarding, yeah, Marcel has a couple suggestions there. I mean, you could certainly, if you are not asking for spousal, you're going to get that put through a lot easier. If you did not put that on the original petition and one of the parties is asking for spousal now, they could force you to redo your petition and file an amended petition and reserve it. I mean, that's what could happen. That's why it's so important to make sure when you think it's going to be a default, to go through everything and make sure everything on your petition is going to match. If they're waiving spousal support, then I would move forward with doing a couple of the things like Marcella is saying. Either put on the FL 170, attach one of those attachments, and put that inadvertently did not check mark the box but was not requesting spousal support for either party. That would probably get it through and make sure the judgment says that. But if they're requesting spousal, they're probably going to have to do an amended petition and reserve the other party, or it's just going to keep getting kicked back.
Okay. Okay. And Myrna says, can you have a sample to show where you put your stamp? Does your other class have paperwork with the stamp? Maybe.
That's so bad. I'll get a sample ready if they're going to be in the next class, or I can send it to her. Oops, I don't have it right here. Because I'm not sure on the other one as well, because I printed them directly out of my computer. So I'll double check. If not, I'll have one ready that I can pull up on the screen for at the end of the next class, question and answer time.
Awesome. Marina Foster said they could do in the MSA too, right?
on that sounds like she's asking that in regards to Victoria's question, where she keeps getting hers kicked back. Absolutely. If both parties are involved, you can do an MSA, and it doesn't matter what was on their first petition or on the original petition. If both parties are signing an agreement, the judges are much more lax about that. It's only if you're doing a pure straight default where the respondent is not participating that's going to become a problem. But yes, if they can agree to an MSA, you can bypass any deficiencies or any problems at that point. It makes the court quite happy.
I've noticed that sometimes we'll put in a petition that we want spousal support to be terminated, but when one party is not involved, the court will scratch that off and put reserved for both. So sometimes I'll see the court will make a decision for the parties, even if it's not the one they wanted. So sometimes so now what I started doing, if the person's not involved, if I get a case at the tail end, and I'll put reserve for future determination for both, if that's what the client wants, and it'll go through fine. That's one possible.
Right. And I definitely know if it's over 10 years, you don't even try and terminate it, especially if it's a default. They absolutely will not. And quite frankly, my clients that are over 10 years and they're entering into an agreement, I tell them that we're reserving it. And I explain that there has to be a change in circumstance, and the language in my MSA says that, which you'll see in the next class. Because I have had them kick back even in agreements before because they don't have attorneys, and the courts don't like them to give up spousal without at least having an attorney consultation. So if it's over 10-year marriage, definitely you want to put in there to reserve it. I have had the courts terminate if it's been under 10 years, even on a default. But if you're just not sure, definitely just reserve it and just keep it a reserve. Hardly any that ever goes back on anything, but that'll at least get your divorce through.
Okay. Perfect. And then Marina Foster made a comment. She said if a fee waiver is involved with the summary dissolution, both will have to qualify for the fee waiver since they're both the petitioners, or the filing fee still needs, and I guess the question is, or does the filing fee still need to be paid for whoever doesn't qualify?
No, that would be true. The fee waiver would have to apply to both of them because it is only one filing fee in this case. So maybe better for them to go in halvesies on it. And, if they're getting along to the extent that they can both sign that petition together, then they should be splitting costs on all of this anyway, for the streamline. But yeah, they would both have to qualify for the fee waiver. I didn't put in any samples of fee waiver on this, but obviously the fee waivers apply in divorce as well for your parties. If they qualify, do that as well.
Maria's question is, if you do an MSA, does the respondent have to pay the filing fee?
No, if you do that properly, and that's what I show in my next class, is default with an MSA and also default without an MSA, but with children. So that's where I use all those numbered forms. So I give that sample in the next class. But no, that's how I get parties to agree. I tell them that, we do, and that's how I get them to pay me more and do an MSA with all of their divorces, is I let them know that keeps them from having to pay that second filing fee of $435. Yeah.
Okay, and then we have just a few more minutes left. I think one of the questions is for a divorce, a regular divorce by default, what is like a general price or range that one can charge for something like that?
A regular divorce with default, that can vary a little bit because if there's children. Now, if there's an MSA involved, I actually give a better price on that because it's easier for me to do a template. So I would say you're going to be right around $1,000 with an MSA. If you're doing a default with children without an MSA, you might even want to charge about the same, if not even a little more, because you have to really make sure your forms match well, that you're giving a lot of description, that you're going to have to do CAL support or DismaSter and attach that onto your calculate, so the judge has some calculations to set spousal or child support. So it always matters based on your experience and what county you're living in. But a full-on divorce, full default, or with a settlement agreement should always be around $1,000, a little bit under, a little bit more, depending on your area. Some people who have been doing this a lot longer charge way more than that. I know some people can charge up to a couple grand for their divorces. So
Thank you very much. I'm in San Francisco. I got the Facebook's plans and the Google plans, and I charge about 1,500, and then it starts going up from there if I include that MSA, like you mentioned. So just try to get the most you can for it, and then if you have to make some adjustments, then do that. But always ask for you know, the most you think that the market is able to pay.
I agree. Great. That's great.
Awesome. So we're now wrapping it up. Everyone, thank you so much for joining this class. Jenny, we are so appreciative of your contributions to CALDA as a member, as a speaker, as a board member now. Thank you for everything. And everyone, thanks for joining this class. And we'll see you guys at the next event.